Thank you.
Thank you, Madam Chair. I'm Kent Scheidegger with the Criminal Justice Legal Foundation. I've been representing the interests of victims of crime for almost 30 years now, and much of that has involved capital cases. California capital appeals take longer than is the norm in many other states. We've known for many years how to fix that. Legislative efforts have been unsuccessful, so now we must turn to the initiative. The main focus I want to talk about is the habeas corpus cases, since that's been the subject of several questions. Capital habeas corpus in California is routinely filed in the state Supreme Court, which generally decides the case without referring the case to a trial court. No other state, to my knowledge, does that. Habeas corpus cases are mostly factual. Their purpose is to consider factual allegations outside of the trial record. They rarely involve unresolved questions of law, and that's the sort of thing that belongs in the trial court. Other states either begin them there or they routinely refer them there. Under this initiative, the habeas corpus petition would be normally filed in the trial court and normally assigned to the original trial judge. That's what the federal system has been since 1948, a system widely copied in other states. The Supreme Court of the United States has noted that the trial judge is the one in the better position to judge such claims as ineffective assistance of counsel, which is one of the most common claims in these cases. It is far more efficient for a single judge who is already intimately familiar with the case to review these voluminous petitions rather than 7 justices cold to the case, taking it from scratch. It's not unusual for these petitions to sit in the California Supreme Court for years. The trial judge's decision would be reviewable by the Court of Appeal, and as the LAO mentioned, that is a new layer, but it's still more efficient overall because when a court is reviewing the decision of another court, when it already has a thorough opinion disposing of all the claims, you can pretty easily pick out the 1 or 2 claims that may have a real substantial basis and more easily dispose of the remainder. So I think that even though there is an additional layer, it is still a far more efficient system, and that's why practically every other jurisdiction has it. The second issue is the so-called successive habeas corpus, a second or third or fourth habeas corpus petition filed by somebody who has already had one petition reviewed and denied. In the case of In re Reno, the California Supreme Court described the abuse that goes on routinely in these successive petitions. Petitions of many hundreds of pages, many hundreds of claims, most or all of which are clearly without merit. These are routinely filed. They serve no purpose. In most cases, they are delay and expense with nothing to show for it. This initiative would make a major reform with a rule against successive petitions, and unlike the current vague exceptions, it would have a clear, simple exception. We would continue to allow successive petitions for claims of actual innocence or actual ineligibility for the penalty, such as, for example, intellectual disability. Such claims are rare. We have not had anyone found actually innocent in California. We have had some found ineligible when the Supreme Court retroactively changed the rules of eligibility, but that was a one-time event. So we would preserve successive petitions for the claims of actual innocence. That's an important safeguard. The question has been raised whether a limit on successive petitions is constitutional, whether it might violate the suspension clause. The U.S. Supreme Court answered that definitively when a similar claim was raised against a reform passed by Congress in the case of Felker versus Turpin in 1996. It's important to remember that most capital cases involve no question of innocence. The bulk of litigation involves questions irrelevant to innocence. So we would preserve successive petitions for those that do, focus on innocence, and if we do that, if there is a case of actual innocence, we're more likely to discover it sooner. This is a carefully drafted and well thought out proposal. It would address delays and reduce costs without loss of ability to correct actual miscarriages of justice. Thank you.
Yeah, I just want to, as someone that represents South Los Angeles, where unfortunately I do have a portion of the Rolling Neighborhood Crips territory in my district, and I know how devastating that was back in the 80s. As a protege of Tom Bradley, someone that I know, Mr. Alexander, that you know and respected. And I know what he did for me in my life to make sure I stayed on the straight and narrow. And, you know, playing football or running track in the old Southern League, where you had LA High, Fremont, Washington, Dorsey, and all those schools. And as competitive we were, there was always the fifth quarter where it could get pretty dangerous. I know what it was like back in that day. And when I heard of your story, it not only touched me as a young person just getting out of school, I think it touched the whole community about how senseless that shooting was. And so I just want you to know every member on this committee feels for you and understands completely how you feel. I guess most important, how frustrating it must be when you depend on the system to work a certain way, and you're kind of guaranteed that, and it doesn't. And so I just want you to know how empathetic we are to what happened to you and your family and your plight. And it's I've never met you. You know, the time I did know you first time, I was an undergrad at USC, so it wasn't always good times when I would see you on the football field. But you did become an LA Rams, and so which you're back again. And so I just want you to know that this initiative, whether it passes or fails, hopefully we get the message out that we, as the rest of the people here are telling, that we really look seriously at how we deal with death penalty cases. And I think this is great that we're able to openly discuss it now and to openly go to the people of California and say, what do we want? Because it's really about what do we want as a community. And so I'll just end with, before I get too choked up, to let you know, Mr. Alexander, and obviously the district attorneys here and the others who are working on this, I know it affected your lives deeply. And so I just want you to know that we do definitely understand how committed you are and how important it is to you. Thank you.
If there are no other questions or comments, thank you very much. And we'll move to the next panel, which is the opponents. We'll hear from Natasha Minsker, Director of the ACLU Center for Advocacy and Policy, Alex Simpson, Associate Director of the California Innocence Project, and Joseph Schlesinger, Executive Director of the California Appellate Project in San Francisco. Thank you. Again, in any order you want to proceed.
Thank you. Thank you, members, for taking the time to consider this very important issue. My name is Alex Simpson. I am the Associate Director of the California Innocence Project. I've been with the California Innocence Project since 2001, and in that time I've seen a lot of issues relating to something that I think we touched on a little bit at the morning session that touches on the death penalty, and that's the issue of innocence. There have been, just looking nationally, more than 1,700 exonerations since 1989, and there have been more than 150 exonerations from death row in that same time period. Through advancements in forensic technology like DNA, through other factors, which I'll talk about in a little bit. The reason I'm mentioning these large numbers is because the issue of the death penalty is directly relevant to whether we get it right every single time. If we don't get it right, then there's an error rate. At a certain point, we will execute an innocent person unless we really put some very strong procedural safeguards in place. If the issue is, as the proponents of this initiative have proposed, if the issue is whether we should accelerate the death penalty, then speeding it up will dramatically increase the likelihood that we are going to execute somebody for something that they didn't do. A review of exonerations in 2015 shows a number of telling statistics. First of all, 2015 was the year that it was the highest number of exonerations nationally that we've ever seen. The average time that those exonerees spent behind bars for crimes they didn't commit was 14 and a half years. If you're just looking at homicides, which obviously we're talking about the death penalty, we should look at homicides. Again, 2015 was the highest number of homicide exonerations that we've ever seen. And the average time that an individual spent behind bars for homicide that he or she didn't commit was 16 years. So if we're looking to speed up the death penalty, we have to deal with the fact that at some point, if we speed it up past that period of time, past that average, we will kill someone who didn't do it. If we haven't already in California, it's because California doesn't execute as many people as other states do. The criminal justice system, and I don't think this is going to be a surprise for anybody, the criminal justice system isn't some unique process by which if you go faster, then you're less likely to make a mistake. If you speed things up, you will make a mistake. That's how anything works. And there's evidence of this in other states. State with the highest number of executions, Texas, by far. State with the highest number of suspected innocent people who have been executed, Texas, by far. Including cases that I'm sure everybody's familiar with, such as the case of Cameron Todd Willingham, who we discussed a little bit in the morning session, executed in 2004, I believe, for a murder, arson murder, and since his conviction, before his execution, changes in arson science showed that there was a high likelihood that the fire was not arson. When I was preparing my comments today, I was thinking what the opposition might say, or what the proponents of this initiative might say to what I'm saying. And I often hear that when we're talking about the death penalty, that some people say that death is different, that we are only talking about the worst of the worst, people that we know committed the crime. And if that were true, then we would have zero exonerations. If that was correct, if we got it right every single time, we would not have 156 people whose convictions were reversed off of death row. And the statistics actually don't bear out that argument anyway. Death penalty exonerations account for approximately 9% of all exonerations, but the death penalty is imposed in only a tiny fraction of all cases. So there's far more death penalty exonerations than there should be statistically. There's fewer than 1% of cases actually get death. And if you're talking about whether or not the statistics would reflect the death penalty's impact, you would expect to see that fewer than 1% of exonerations come from death row. But the death penalty is far more represented in the statistics. Why is that? There's nothing really special about death in the sense that there are still the same types of factors that go into wrongful convictions when you're talking about the death penalty. Eyewitness misidentification, for example, is by far the largest factor, as it is with other exonerations. There are some things that the death penalty you see more often than in other exonerations. False confessions, for example, you're far more likely to see a false confession in a death row exoneration than you are in a standard exoneration from a case that doesn't involve the death penalty. But why are there more death penalty exonerations than in other cases? I think it's very easy to understand, because there are more resources on the back end when you're talking about the death penalty. We spend more resources to make sure we get it right. And again, there's nothing unique about the death penalty where if you spend fewer resources on double-checking your work, the more accurate you're going to be. In fact, it's the opposite. If you spend fewer resources checking to make sure you got it right, the more mistakes you're going to make. Some of the comments, and I'm just going to address very briefly, Senator Hancock, you had questions about additional levels of review that I think the Legislative Analyst's Office had commented on, and I think Senator Leno had some questions about whether or not habeas review happening in the same court that actually convicted the person and sentenced somebody to death. I don't want to get inside baseball on everybody, but just to remind everybody, what this initiative does is it does create just one level of actual review, which is one round of habeas review. It's in the trial court instead of the California Supreme Court. Everything else is an appeal, which means that the appeal will only determine whether or not the trial court acted according to the law. It won't re-review the evidence. Why is another reason why we have more death penalty exonerations than the statistics should show? Because we have the very best people looking into the convictions after the conviction. Ineffective assistance of counsel is one of the major factors behind wrongful convictions. If we have ineffective counsel reviewing an ineffective attorney's work, then there will be fewer mistakes discovered. So in conclusion, what we know beyond any doubt is that the criminal justice system has an error rate. That's actually not something that I think we knew 30 years ago. But with the advent of DNA, we know that people get convicted for crimes they didn't commit. And it's such a huge problem, what we're talking about, that even prosecutors agree that there is an issue. Mike Ramos, the proponent of this initiative, Mike Ramos, about a month and 2 weeks ago, enacted and announced that his office was creating a conviction integrity unit to review his convictions from his office. The reason why we do that, why you see more conviction review units popping up, why you see more exonerations every year, is because we are learning more and more about the factors, the issues that have to do with the criminal justice system. And if we speed things up, if we take resources away, we increase the likelihood that we will kill someone who didn't do it. Thank you.
Thank you.
Good afternoon, Senator Hancock, members. My name is Joseph Schlesinger. I'm the Executive Director of the California Appellate Project, or CAP. CAP is the agency charged with supervising, assisting, supporting, and training the lawyers in private practice, mostly sole practitioners who take capital appeals and habeas cases. I'm also a member of the Board of Directors of the Habeas Corpus Resource Center, so I'll be one of the 5 people out of an unpaid position if this initiative passes. I'm here to talk primarily about the panel, but I'm uniquely situated to talk about questions involving the Habeas Corpus Resource Center. I was also in charge of the Federal Defender here in Sacramento Capital Habeas Unit for 17 years, so I'm quite familiar with the federal process as well. The single biggest problem we have on appeal post-conviction is the shortage of lawyers able to handle the cases. Of the 743 people now on California's death row, 360 of them, almost half, don't have lawyers. Some of those people have been waiting for lawyers for over 20 years. If we eliminated just that one source of delay, our cases would proceed through federal court in about 8 to 10 years, which would put us on a par with the national average. This initiative won't do anything to help with that problem, and it's almost certain to make that problem worse. What we need to do is restore the funding to the Office of the State Public Defender that was slashed in the 1980s, and to lift the cap imposed by statute on the Habeas Corpus Resource Center for the number of lawyers they're allowed to hire. But we're not talking about doing any of that. Instead, the proponents claim to have a better idea. They say, I know, let's impose a lot of draconian time limits on the entire process that will make taking a capital appeal or habeas a really, really unattractive proposition. Sure, that will probably dry up the entire pool of lawyers now willing to take the cases, but here's the thing, we'll just force other lawyers to take these cases. Does anybody seriously think that will work? You can't force people to take a case or work they don't want to take. And if anybody's going to resist something like that, it's going to be a group of lawyers. And we don't have to guess about that. The non-capital lawyers who would be affected by this proposal were asked, what would you do? And 72% of them, almost 3/4, said, we will resign from the non-capital panels rather than take a capital case. The ripple effect throughout the system will be devastating, and if there was an award for the proposal most likely to throw a struggling system into utter chaos, this would win hands down. So one of the proponents' main talking points is there's plenty of qualified lawyers, but the prerequisites for appointment are just too high. Well, that's not the case at all. The appointment standards were adopted in 1998 by the California Supreme Court, and at that time they looked at the standards all over the country and they picked a path straight down the middle. Our standards are equivalent to the standards in Florida, Georgia, Texas, Alabama, Virginia, Arizona, Mississippi, Idaho, Colorado, and Montana, as well as others. In an important respect, California is more inclusive than any of those states because we have what's called a catch-all provision. You don't have to meet the regular standards laid out in the rules. An attorney can appoint it if he or she has equivalent experience, making them qualified to take a capital case, and about 20 to 25% of the lawyers on the panel got on through that catch-all provision. It's not something that just exists in theory. It's used and frequently used in practice. And experience prosecuting cases is specifically listed as one of the alternative qualifications. The proponent's other main talking point is that panel membership is supposedly controlled by the defense bar with a supposedly abolitionist agenda. That, again, is just flat out wrong. Panel membership is controlled by the California Supreme Court, not the defense bar. No one's more concerned about the backlog in appointments than the California Supreme Court. Most of the lawyers who apply for a case get onto the panel. When the court rejects an attorney as unqualified, it's with great reluctance, and court staff works closely with the applicant to improve their qualifications, making specific suggestions. Take a non-capital case somewhere. Do another felony in the Ninth Circuit or somewhere else, and they're encouraged to reapply. We'll be unable to provide the quality of representation required by the Constitution if all we require is a law school diploma, and that's really the only way you can drop the standards low enough to think that you might get enough applicants. Even under current standards, some lawyers are underperforming, and from time to time they need to be removed from their cases for inadequate performance. We can't risk the wholesale denial of due process by dispensing with the standards entirely. The proponents aren't content, however, to deal with the appointment backlog. They want new sweeping time limits across the board, and that's most of what we heard earlier this session, not much about the backlog of cases. These are experimental proposals that have never been tried anywhere and would have disastrous consequences, not only in death cases, but to the fair administration of justice as a whole. The California Supreme Court works very, very hard on these cases. The capital appeals comprise about a third of its docket, and the court decides about 20 capital appeals per year. There are approximately 350 capital appeals now pending in the California Supreme Court. To decide those cases within 5 years, the court would have to decide 70 of them per year. That's more than triple the current figure. All other work of the California Supreme Court would stop for years to come. And we heard some about transferring the habeas corpus proceedings to the trial courts. Well, where are we going to get the trial judges to do those cases? They won't be distributed evenly. They go back to the jurisdiction where the conviction was had. Take Los Angeles County, for instance, which is one of the most understaffed counties judicially in the state. We're short 44 judges in Los Angeles. More than 100 of the unrepresented defendants on death row come from Los Angeles. Los Angeles County courts would stagger under the weight of 100 new habeas petitions that they have to decide in a year, not 2 years as we heard from LAO. It's 2 years if the claim is innocence. So 100 cases filed in a year, and probably 99 of them had to be decided in 1 year. Civil litigants in LA County would have no place to go to get their disputes resolved. There's the same problem in Sacramento, Fresno, Orange County, Riverside County, San Bernardino County, and Kern counties. And to make the bad situation worse, the proponents want to impose the limit that all habeas petitions be filed within a year after sentence is imposed. That's not enough time to work up the case, and no one will take a case under those kind of time restrictions. The California Supreme Court has determined that a minimum, not maximum, of 3 years is the time that's reasonable to prepare a habeas petition. It's difficult enough to do an adequate job in that amount of time. It's not possible to do it in 1/3 of that time. Now, some states do have a 1-year statute of limitations, but none of them have trials as complex or extended as ours. A California habeas lawyer is tasked with reviewing tens of thousands of pages of a trial court record, reviewing a trial attorney file that often consists of dozens of banker's boxes or more. No other state has cases like ours, and they have to understand their client's life and background from birth or earlier. They have to investigate all prior offenses. They have to investigate the trial proceedings themselves. That can't be done in a year. And most importantly, as I just said, yes, some other states have a 1-year limit, but that 1 year runs from the date of affirmance on appeal, not from the date of the death sentence. So lawyers in those states working under a theoretical 1-year time limit actually have more time than our lawyers in California currently have with a 3-year time limit. As to this notion that the well-organized defense bar is clogging up the system with frivolous claims, that just does not exist. The Reno case referenced by Mr. Scheidegger was a very special situation with a special rule where the California court said, if you have to come back from federal court just to exhaust a claim in federal court and you think you have to reallege everything else in the case, just tell us what you're realleging. There was nothing about frivolousness in there. So, and we have to remember that some of our bedrock principles of federal constitutional law, state constitutional law, were once deemed frivolous. It wasn't that long ago in death penalty cases that it was considered frivolous to argue that the death penalty couldn't be imposed for rape, or that juveniles or persons suffering from mental retardation couldn't be executed, or even that people who were innocent could not be executed was once deemed a frivolous claim. This initiative is based on a fundamental misunderstanding of how the process works, who's in charge, where the problems lie. It's based on magical thinking that we can produce qualified and willing, or more accurately, unwilling lawyers out of thin air. It's a recipe for bringing down a system that's already collapsing under its own weight. Thank you.
Thank you.